Hi, everyone. Welcome to the VYAP Collaboration Event, which is part of the official agenda of Singapore Convention Week. This event is jointly organized by the Very Young Arbitration Practitioner chapters, or VYAP chapters, of Singapore, Madrid, Portugal, Paraguay, Australia, Dubai, Colombia, Paris, and China. My name is Sunita Advani, and I'm the founder and chair of Singapore Very Young Arbitration Practitioners, or SGVYAP. Today's event comprises the screening of the documentary The Tribunal and will be followed by a panel discussion on ISDS. Before we begin, I would like to thank our event sponsor, King & Spalding, our venue and technology sponsor, 20 Essex, and our overflow room sponsor, Maxwell Chambers. We will now watch a video containing messages from our lovely VYAP collaboration partners and their introduction of the speakers, followed by the documentary and then the panel discussion. Thank you.
Hola a todos. Hello everyone. My name is Juan Camilo Jimenez Valencia. I'm a senior associate at Anotiu and Vandenberg in Brussels. I'm also a co-founder of Colombian Very Young Arbitration Practitioners, and I'm sitting in the board of directors. Sitting with me in the board, we have Laura Galindo, who works in Meta in Germany, Juan Camilo Fandiño, who works as an associate in Debevoise and Plimpton in New York, Nicolás Esguerra, who works as an associate in Latham Watkins, also in New York, Nicolás Caballero, an associate at Hogan Lovells Miami, and Nicolás Rosero, an associate and Estudio Echecopar Baker McKenzie based in Lima. We founded COLVYAP in 2015, and it has been a wonderful roller coaster so far. We have done a very successful mentoring program and in-person events both in Europe and the Americas, and also online webinars. We are delighted to work with the other VYAPs in the Singapore Convention Week, and we just want to note that this is the third time that we're collaborating with SGVYAP. I have had the pleasure of visiting Singapore 3 times so far, and I absolutely love your country. From attending hearings in Maxwell Chambers, having lunch at Otto, or just strolling by Sentosa or throughout gardens by the bay. It's a wonderful country, but what strikes me the most is how efficient everything is since the moment you set foot in the country, how beautiful and clean and organized it is, and how safe I feel. I really believe that you have a treasure there, and I really hope that I can go and visit your country once again very soon.
Everyone, my name is Ernest Morales, and I'm an associate at Mourques LLA Arbitration in Paris. I'm also one of the co-chairs of Paris VYAP, which was founded on 2012, making it the oldest in the VYAP network. The current board is composed of Karim Zain, Katia Ogrevnova, Neil Daber, Florian Renaud, and me. All lawyers specialized in arbitration and based in Paris. We organized several events throughout the year, and our last event was an event co-organized with Madrid VYAP and Portugal VYAP, which is an example of how the VYAP network can collaborate amongst themselves and organize events that involve different VYAPs. So in the same spirit, we are thrilled to be collaborating with various VYAPs on the Singapore Convention Week 2024. Singapore is probably the fastest growing seat of arbitration. It's already a crucial player in the arbitration world, and so it is very exciting to be connecting arbitration lawyers of the future in the future of arbitration. So if you want to know more about what the events that we organize and all the activities that we plan on doing in the near future, do not hesitate to follow Paris VYAP on LinkedIn or to connect with any of the co-chairs of the board. See you soon in Paris.
This is Very Young Arbitration Practitioners China chapter. My name is Angela Yan. I'm one of the founding members and the chair of China VYAP.
Hi, this is Yifei Zhang from VYAP China chapter. I look forward to meeting more young arbitration practitioners here and getting more practitioners in China to join this community.
Hi there, this is Julie Guo from Luxembourg, China. one of the founding members of VYAP China chapter. I'm excited to send my best wishes and hope the event to be a great success.
Hi everyone, this is a very young arbitration practitioner China chapter. I'm Peng Yanbing Sandra. I'm one of the founding members of China VYAP.
Hey there, I'm Jingjing Li from Zhonglong Law Firm. We are happy to collaborate with Singapore VYAP for this great event. Singapore's arbitration web and starting scenery have always stolen my heart. Calling all the young lawyers, get ready for this unforgettable experience in Singapore.
Hello, everybody. It is my pleasure to introduce you to Madrid Very Young Arbitration Practitioners, VYAP, although based in Madrid, covering the Spanish chapter and founded in 2019.
Our mission is to forge connections between emerging jurists and experienced professionals, disseminating the value of arbitration and underscore the significance of arbitration as a mechanism for dispute resolution.
We champion networking activities where young arbitration enthusiasts can integrate into the broader arbitration community. And by the way, never been to Singapore, but looking forward to an invitation.
We also organize academic events such as roundtables with experts and with academic institutions. Moreover, through our partnership with Gismundi, we offer analysis on recent case law and legislative updates.
To engage with VYAP and partake in our initiative, we invite you to follow our LinkedIn page, Madrid Very Young Arbitration Practitioners.
MadVYAP is not just a project, it's a community that belongs to all of us. We are eager to get to know you and to see you in our upcoming events.
Good morning, everybody. My name is Jorge Bogarin. I am from Paraguay. I'm 31 years old, and I am one of the 5 people that co-founded Paraguay's Very Young Arbitration Practitioners. We are a rather new chapter, as our chapter was founded earlier this year, and we look forward to many upcoming projects and collaborating with Singapore's Very Young Arbitration Practitioners. I wish everyone attending this event the best, and hopefully we will attend in person the upcoming events organized by such an amazing chapter.
Hello all, my name is Mika Schwarzstein and I'm the co-founder of VYAP, which is the first VYAP chapter established in the continent of Oceania. We are based in Australia and we were established in October 2023. We are very much looking forward to collaborating with the Singapore chapter of the VYAP organisation for this event. And I personally have never been to Singapore, however I do commend Singapore for its efforts in wanting to build a more sustainable future, and particularly its efforts in wanting to conserve and preserve the environment as well. Thank you very much for your time, and if you do want to link in with our chapter, you can find us on LinkedIn. Thank you very much, and wishing you all the very best.
Hi all, my name is John V and I am one of 6 committee members that have established the Dubai chapter of the Very Young Arbitration Practitioners Group. Our committee consists of Antonin Sebek, Farhan Shefi, Grace Go, Malavika Vijayan, Peter Barna and myself. We're still a fairly new chapter, as a result of which our identity remains somewhat of a mystery in case this logo was not telling enough. But that said, we intend to properly kick off post the summer period in Dubai, and we'll be hosting both social and learning and development events on a regular basis. So we would love to welcome you if you are ever stopping by in Dubai. Please do not hesitate to get in touch, and we look forward to seeing you at future events. Thank you.
Today, I am both honored and sad to be introducing the panel. Honored, of course, because as you will see, it is an absolutely stellar panel, and sad because I'm doing this virtually. Hence, I will not be able to enjoy the delicious chili crab that I so much love in Singapore. The panel is composed by Mr. Luke Sobota, Ms. Sarah Grimmer, Ms. Hannah Askia, and Ms. Sunita Piyadvani. Luke Sobota is a founding partner of 3 Crowns. His practice is dedicated to commercial, investor state, and interstate arbitration, and he has extensive experience in the technology, energy, and financial sectors. He has also more than 25 years of experience litigating international issues in U.S. courts. A lecturer on law at Harvard Law School and an adjunct professor at the University of Miami, Luke is also the co-author of International Arbitration, Three Salient Problems, Cambridge 2020, and General Principles of Law and International Due Process, Oxford 2017. Luke is a member of the board of SEAC and is vice president of the ITA's executive committee. He previously served as a law clerk to the Chief Justice of the U.S. Supreme Court and worked at the U.S. Department of Justice. Sarah Grimmer is a full-time arbitrator at Twenty Essex. She has over 20 years of experience in international arbitration. She sits as an arbitrator in international commercial and investment treaty arbitrations. Sarah has worked in 3 leading arbitral institutions, the ICC, the PCA, and the HKIAC, the latter of which she led as Secretary General from 2016 to 2022. Hannah Askia is an associate in King & Spalding's Singapore office and a member of the firm's International Arbitration Group. She has represented clients on investment treaty and commercial arbitrations under the rules of major arbitral institutions including ICSID, SEAC, ICC, and GAFTA, as well as ad hoc arbitrations under the UNCITRAL and SCMA arbitration rules. In addition to acting as counsel, Hannah receives arbitrator appointments and is an accredited mediator with the Singapore International Mediation Institute. She is ranked as a future leader in Who's Who's Legal's report on Arbitration Future Leaders Non-Partners 2024. And finally, moderating this panel, we have Ms. Sunita Piyadvani, who acts as a tribunal secretary to Mr. Michael Lee, an English arbitrator member of Twenty Essex. She assists Mr. Lee in his high-value and multi-jurisdictional commercial arbitrations across numerous industries and administered by top arbitral institutions such as the ICC, LCIA, and SEAC. Sunita previously practiced international arbitration as a junior associate in a leading international law firm in Singapore. She read law at the University of Nottingham and the University of California, Berkeley School of Law. She is admitted to practice law in Singapore, England and Wales, and New York. She is also the founder and chair of VYAP. I leave the floor to Sunita. Thank you very much.
I'd now like to invite Luke, Sarah, and Hannah to take their seats at the front. Before we begin the panel discussion, I just want to say that we will have an audience Q&A round at the end of the panel discussion. And if you're seated here in Twenty Essex, you can of course raise your hand and ask your question verbally. If you are seated in the overflow room at the Flamingo room, even if you're here, you can also submit your questions by Slido. For those who are joining the event on Zoom from all over the world, you may submit your questions via the Q&A function on Zoom. So with that, I'd like to start with the first question, which is for Sarah. Central to this documentary is the theme that investor state arbitration, this one in particular, did not adequately address, at least to the minds of the community members in the Intag Valley, the human rights violations that occurred to them. Are tribunals adequately equipped to handle human rights issues as well as other socio-political considerations that bear on the dispute? If not, how can they do so? Why have they often not taken human rights issues into account? And what would need to change in order for them to do that?
Thanks, Sunita. I think after watching that movie, the impression we're left with is the profound sense of injustice with the Intag people in Ecuador. They're asking themselves, how can it be that this tribunal, made up of individuals from the other side of the world whom they do not know, who've never been to the Intag Valley, who have never seen the Intag Valley, have never heard from these people in the process of the arbitration, how can it be that they have decided that the Ecuadorian government, and therefore them as citizens, taxpayers, has to compensate this foreign company that came in for profit-making purposes and threatened severe damage to the land, contamination of the water, and terrorized the people? How can it be that they, the victims, have to pay the company. And, you know, you can appreciate that from their perspective, it's outrageous. And I think that there are two factors that feed into this, this result at the end of the investment treaty arbitration. And the first is that there is not a complete lack, because there were some people we saw on the film who did appreciate some of the nuances of investment treaty arbitration. But there is, I think, amongst the community, a real lack of understanding. This is not a criticism, it's more a factual statement as to what investment treaty arbitration is, but more importantly, what it is not. So investment treaty arbitration is necessarily focused on the obligations of states owed towards investors. So that is the focus of investment treaty arbitration. It is not focused on the human rights of the citizens of the host state. It's not a human rights claims tribunal. So that's the first factor. And I think the second factor that really comes through is the real distance between the people in the community and the arbitral tribunal. They do not know them. They do not know how they were put in place. And so that really impacts, and they have no role in the process. And you heard there that their witness testimony was sought by their lawyers, but not eventually put before the tribunal. And I think that that's a real disconnect. And I think that we're going to talk about amicus and transparency a little bit later. But when I watched that movie, one thing that came to my mind, and it's perhaps something we don't talk about too much in investor-state arbitration, is how states choose the arbitrators that they appoint, because you can appreciate that the impact for those people in that community of having an Ecuadorian national on that tribunal, there would have been an impact, even if it had no impact ultimately on the substance. But that's just something that struck me. And, you know, it's quite common for states not to appoint a national, their own national for various reasons. But I think that that goes towards the efforts that are being made to increase diversity as a means of increasing legitimacy. But Suni, to your question, which is, are tribunals adequately equipped to handle human rights issues? If you put it as a yes or no question, my short answer would be no. But I think I wouldn't quite pose it like that. I wouldn't say, are they well equipped? I would rather pose it as, is it the tribunal's mandate to handle human rights issues? And I would say that human rights issues are relevant in investment treaty arbitrations sometimes, but the tribunal's primary mandate is to deal with the legal issues as they arise under the treaty. So these are issues such as, is the investor or is the claimant a protected investor? Is the investment a protected investment? Has the state unlawfully expropriated the investment? Has the state afforded fair and equitable treatment to the investment? And somewhat ironically, in the context of this movie, has the state afforded full protection and security to the investor? So those are the kinds of questions that tribunals are primarily concerned with, because they are applying and interpreting the treaty. Human rights issues are relevant sometimes, and I'll make 3 points. The first is that, as I've said, tribunals apply the treaty and they interpret the treaty in accordance with international law. Now, of course, international human rights law is a part of international law. And investment treaties must interpret the treaties in harmony with international law. And so that's where you can bring in human rights law. But what does that mean in reality? So let me give you an example. So say you have a claim brought by a claimant with respect to, say, denial of justice. And the tribunal has to ascertain, well, what is the standard to meet a denial of justice claim? What is that standard? So there they may have recourse, or they may look at jurisprudence arising out of the European Convention on Human Rights, and that will inform their assessment of the standard. But that tribunal in the treaty arbitration context would not then go on to find that a state has breached the European Convention of Human Rights. That's outside of its mandate. Another point to be made is that sometimes treaties do refer to human rights or human rights instruments. For example, in the preamble, And that's all part of what treaties must use in terms of interpreting the content of treaties. But when we're talking about preambular text, there may, the practical effect of that may be quite limited. But I think the most important point, and it resonates with this movie, is whether or not an investor's conduct that breaches human rights under contracts or domestic law, because, private corporations do not owe human rights obligations, states owe human rights obligations. So can that conduct be the basis for a counterclaim of a state, or can that be the basis of a reduction in damages because of contributory negligence or faults? And you see here in this case, that was the situation, because Copper Mesa had a reduction in its damages claim of 30% because of its own contributory fault, because of the conduct of the company. So, and then my final point is, you asked, well, what if tribunals can't do too much with respect to human rights and it is limited, how can that be improved, let's say, or how can that be changed so they have more influence? And I think, for tribunals constituted under treaties, it all comes back to the text of the treaty. So if states want to give treaty tribunals more power in terms of dealing with human rights issues, then they need to put that in the treaties. And there's an interesting example. It's not in a treaty, but it's in a model VIT. It's the Dutch 2019 VIT, which explicitly allows tribunals to take into account non-compliance by the investor with the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises when assessing damages. So if you have that kind of explicit text in a treaty, tribunals will apply it. Arguable, it may be that tribunals can already apply that without the explicit text, but if you have that in, then tribunals will take it into account.
That's very insightful indeed. Our next question is for Hannah. Several countries have enacted legislation imposing human rights obligations on businesses incorporated in their countries. For example, France has enacted laws imposing a duty of vigilance on parent companies and their contractors. And the EU has also enacted similar legislation by way of the Corporate Sustainability Due Diligence Directive. How effective are these types of legislation in addressing human rights abuses within the context of investor-state disputes? Should more countries be looking to adopt similar legislation in their domestic laws?
Thanks, Anita, for this question. It's really not an easy question to answer. And actually, I think the gist of the answer to this question has very much already been addressed by Sarah, specifically in relation to the interaction between international investment law and human rights due diligence, because it does lead to complex questions, exactly what Sarah just mentioned. And I think the answer is ultimately it remains to be seen. I'm not aware myself of any cases at the investor state level that has arisen as a result of France's Vigilance Act or the EU's. Because again, you must distinguish between domestic law obligations and international investment law. And typically, human rights due diligence, of course, they are at the domestic level, and typically these legislations would provide for enforcement or remedies at the domestic level. And we've seen some cases actually arising in France out of that Vigilance Act. Not that many. Most of them have been dismissed for procedural reasons, and I think there's one on the merits just at the end of last year that was issued. But there's been some criticisms as well, with the model. Just to tie back to what Sarah was mentioning earlier about can then states somehow use these domestic legislations to at the investor state arbitration level. Well, I think two scenarios where that may arise is at the beginning, where they potentially may use it to object to jurisdictions, particularly if the treaty does contain some specific requirements that the investment has to comply with these domestic law provisions. And if the investor doesn't comply with them, then there may be grounds potentially to say that, that the investment is illegal. And then the second scenario, and I think we will touch into it later, so I won't say too much, is at the stage where states think, can I bring a counterclaim, out of these issues? But again, that really requires a very careful analysis of the treaty. And I don't think there's been many decisions at the investor state level where tribunals were willing to find jurisdiction, first of all, and then a favorable decision on the merits. As to your second question, should more countries be looking to adopt similar legislation? Well, put it this way, countries enact various legal legislations dealing with, for instance, anti-corruption, anti-bribery, anti-money laundering, all of which are aimed to prevent damages in the public sector, right? You don't want to undermine public trust in the government. And I read somewhere that the term due diligence in the phrase human rights due diligence is actually borrowed from the common business practice of financial due diligence, wherein financial risks are investigated before any large investment. And so I really wonder, whether we can't see due diligence obligations on human rights in the same light. Should companies not put similar effort into investigating the risk that an activity might somehow violate human rights, just as when businesses evaluate whether they have financial risk? Is human rights something not of the same level of importance? And I think there definitely is a growing consensus in that regard, that you should move towards changing this voluntary language into something that's more mandatory. Because typically, these legislations, what you want is not just to cover risk, but also to create impact. And if the provision is there, potentially then you will see it.
Okay, that's really very interesting. Our next question is for Luke. So historically, tribunals have been reluctant to admit amicus submissions out of concern for relevance, as well as whether these might be costly and disruptive to the proceedings. How has the approach towards amicus curiae submissions with respect to local community members evolved, and how do you see it evolving further in the future?
So a lot of our investment system is derived from the commercial space, where of course most of the arbitrations aren't even public, let alone an opportunity to submit amicus. So obviously in cases like Copper Mesa, where you're talking about questions of regulatory power, police power, potential effects on the public fist, there is going to be public interest. So when this started out in the early 2000s, late 1990s, most institutional rules, ICSID, UNCITRAL, just didn't have a provision for amicus curiae. And so Methanex was really the first case that was an UNCITRAL case to impliedly recognize a power to admit amicus curiae. And then you see the system evolve so that today, 2006, the ICSID rules are amended. 2014, you have the UNCITRAL rules on transparency. You've got the Mauritius Convention. Now, even the TPP has detailed provisions allowing amicus. And I think that's all to the good. You are ultimately trying to, as Sarah said, explain the system and empower people affected by results of that system to have their voices heard. The statistics I've seen have been somewhat mixed. One that I read was that there have been 136 amicus applications since 2001, and in fact, those have almost tripled since just 2016. So the majority of the amicus have been filed just in the last 8 years. A notable example is the World Health Organization filed in Philip Morris versus Uruguay and was able to provide its objective input on the health effects of cigarette smoking. And you see this not only indigenous communities, NGO communities, but trade groups and others becoming involved. The standards by which a tribunal measures whether or not to hear an amicus, it's something of a balancing test, because the amicus need to add a perspective that is not already available from the parties. And so that oftentimes means that purely legal arguments may not be accepted as amicus, but if there is a factual input that the amicus can provide a unique perspective, that can be added. And that leads to the tension, which is almost all of these rules have in some frame or another to test the burden and the unfairness of the addition of a new amicus brief. And obviously, if the amicus is being told you need to add something new of value, then you are shifting in some ways the nature of the proceeding. And you hear from investors who are facing cases that are taking years, sometimes decades to resolve the additional incremental burden of amicus. And so that is oftentimes the balance that tribunals try to strike. And in the Philip Morris case, there were some amicus briefs that were rejected and some that were accepted under that standard.
Thank you. Our next question is also for Luke, and it is, how can ISDS become more transparent to community members impacted by investor-state disputes?
So I think there is education to pick up on what Sarah said at the outset. The individuals in the film just don't have any understanding or transparency into the process. I think there's education to be done both pre-investment and post-investment. Actually, one of those individuals, Mr. Carlos Soria, was a witness, and Ecuador submitted 2 written witness statements on his behalf that Johnny Viter in the award made a point of noting were especially helpful. He was not cross-examined, but that's just a peculiarity of investment arbitration, where if the other side chooses not to call a witness, then their testimony is submitted and given the weight that it was due. And so that, I think, is actually a very interesting aspect where a state has actually brought in the community ex post to assist in the defense of the state, and that gives at least partial involvement, although he was not called to testify. I think part of what you heard in the film, however, was criticism of Ecuador. And once there's a limitation, as Sarah was saying, about what a tribunal can do, because there has to be an investment necessarily to even have jurisdiction. That means that a contract was signed. Jan Paulson wrote that famous piece in 2010, Can States Make Meaningful Promises? And you heard one of the people saying Ecuador is ceding its sovereignty to these international tribunals. Well, that's what Wimbledon and PCIJ said. That's exactly an attribute of sovereignty back in 1923. You're ceding that sovereignty to these tribunals, and the question is, are they getting a return? And that's obviously a policy debate for people to consider. But I think one of the fundamental issues here is just consultation. And clearly, the disputes that you see in Benin arose when the investor was trying to get the community sign off for an environmental impact statement. But the reason for the arbitration is Ecuador had already given a concession. And so then the question arises, what public consultation should have been given then? And I was actually talking to Andres, who happens to be from Ecuador and is on top of this. And today, under a new Supreme Court ruling in 2023 that was mentioned in the film, Ecuador actually has to have that public consultation and have a public vote even before the concession can be granted. And so you've now, you talk about ultra transparency, you now actually have a referendum vote by the affected communities beforehand. And I think it just exposes, as Sarah was saying at the outset, once you've got an investment arbitration, you're now talking about the contractual treaty rights vis-a-vis the investor and the state. And there's only so much you can do in that space to address a lot of the things that you heard about in the film.
That's very useful to know, education and consultation. So our next question is for Hannah. Numerous countries have been terminating their bilateral investment treaties. Why is this occurring? And are there trends in terms of the profiles of countries that are doing so? What does the future of ISDS hold? Is the system capable of reform, or is it fundamentally flawed?
Thanks, Anita. Yeah, so several states have terminated their bilateral investment treaties or withdrew completely from the Convention. You know, some of these states, Bolivia in 2009, Ecuador, Indonesia, where I come from, India and South Africa. They've either terminated some or all of it with the intent to negotiate from a clean slate and or adopt alternative approaches to investment protection. So I think you can see the trend here. The countries that are backing away from this system tend to be developing countries, right? And one of the shortcomings that is often said about ISDS is that there is an asymmetry where the obligation tends to be placed on the state, but not on the investors. You know, so if you look at it, one of the reasons also why these states are considering to terminate their treaties is because, at least for Indonesia, for example, the treaties were signed at a time when they were really needing foreign investment to come in the 1960s, 1970s, or 1990s, right? So Indonesia was not the economy that it is now. And I think that's the sentiment that's also being felt by some of these other countries. But that's not the thinking anymore. If you also consider the economics of it, you know, I've seen charts comparing what does these arbitral awards, if these countries are sued in these sorts of cases, what is the value of the arbitral award compared to how much they're spending for the public? And it's like, here's how much the value of the arbitral award, and this is you know, how much these states have in the annual budget, or what they're spending for the public. So a lot of these countries are thinking it's not really worth the trouble. You know, let's do away with it. Actually, we don't really need foreign investment. But for me, I think there is still hope in the system. I think with global trade, which I don't think you can escape for various reasons, these sort of issues will still come. And that's why there's a lot of conversations about it. The Minister Working Group 3 has been working for some time on various reform options. And I'm hopeful that as long as there's mutual interest on both sides, you know, you will try to find a way in order to make the system work.
Thank you for that. Our final question is for Sarah. What means are available to states in international investment law to defend states' rights and the rights of their citizens?
Yeah, so I guess the genesis of this question goes back to, you know, kind of after you watch the film, you're left with that feeling, well, if investment treaty tribunals can't protect the citizens, who does? And obviously it's the government, right? So there's a lot of searching around the government. Sure, they protect the incoming investor, but what about their own citizens? That's really interesting to hear about the reform in terms of consultation. But, well, first of all, in investment treaty arbitration, there are lots of points at which states defend themselves: jurisdiction, merits, quantum. So, but that's all on the defense. And as the saying goes, the best defense is offense. So what are the offensive, defensive moves that states can take? And then the first that comes to mind, of course, is counterclaims. And there has been a recent publication looking at counterclaims in investment treaty arbitration that I would commend to anyone who wants to read into this a bit more deeply, and that's by Maxi Shearer. It's a 2023 publication in the book edited by Annette Magnuson on investment arbitration and climate change. And there she found 17 counterclaims brought by states in publicly known cases, 17 publicly known cases. But there are a number of hurdles that states will need to overcome to be successful in counterclaims. So the first thing, and it always goes back again to the text of the treaty, is there consent for a state to bring a counterclaim under the relevant treaty? You have some treaties, not many, that expressly grant consent. So, for example, the Slovakia-Iran VIT states that the respondent may assert a counterclaim that the claimant has not fulfilled its obligations under this agreement to comply with the host state law. Okay, so that's explicit and clear. But for the most part, treaties are silent. They don't preclude it. And so then you need to get into an interpretation of the relevant text of the treaty. In one case arising out of the Argentina-Spain VIT, the text refers to disputes arising between a party and an investor of the other party in connection with investments. So quite broad. And in a case arising under that treaty, the tribunal found jurisdiction with respect to the state's counterclaim. By contrast, if you listen to this text under the Greece-Romania VIT, it refers to disputes concerning an obligation of the host state. So there, in a case arising under that treaty, the tribunal did not find jurisdiction over a counterclaim with respect to obligations of the investor. So again, you always go back to the text of the treaty. The second hurdle is one of admissibility, and that is because the question of the counterclaim needs to be connected to the subject matter of the dispute. So then you get into a question of whether or not the counterclaim is legally and or factually connected to the claim. And there's quite a bit of debate about whether it's both legally and factually needed. The connection needs to be both legal and factual, or whether it can just be factual. There are different decisions on that. And then finally, of course, the state needs to be able to identify the source of the investor's obligations. So there has to be a legal obligation that they have breached. Typically, that's going to be a domestic law obligation, because you run into difficulties trying to identify an international law obligation for a private corporation, although you can. It may be in the text of the treaty. And that text that I read out earlier, the Slovakia around VIT, referred to post-state law, so elevated breaches of domestic law into the treaty. But otherwise, you're really going to be dealing with domestic law obligations, and then it's a question of whether or not they do need to be elevated to the international plane to come within the scope of the tribunal constituted under the treaty. But for Ecuador, out of the known counterclaims brought by states, 2 successful ones were brought by Ecuador in the Parenco Ecuador case and in Burlington, Ecuador. So I guess that's somewhat of good news for Ecuador.
Thank you, Sarah. So I would now like to invite the audience to either submit their questions on Slido or Zoom, or raise your hands if you have any questions, and if you're seated here at Twenty Essex. We have a few questions. We'll start with Andres, who's from Ecuador.
Thanks very much, Sunita, and to all of you. It's a very interesting topic, and of course close to my heart, being from Ecuador. My question for the panelists is, do you think that investment arbitration is falling short when it comes to transparency? Because I think what we saw in the film, and Luke mentioned something about this, is a lot of people, they don't really understand what's going on. One of the people interviewed, she said, I don't know who the arbitrators are going to be, who appoint these arbitrators, etc. And do you think that maybe that's one of the key issues here? Because when it comes to the amicus curia part, right, I could feel from the field that a lot of them really wanted to be heard by the tribunal, but I wonder, even if the tribunal will allow all these people to speak there, right, and intervene, would that be relevant or useful? Because if the citizens will have said, I mean, maybe what they were trying to achieve or what they were trying to prove is that Ecuador did not comply or did comply with the public consultation process, but are those issues within the scope of the jurisdiction of the tribunal or not, right? So maybe I think transparency was more of a key issue there. So my question is that, do you think transparency is needed in investment arbitration nowadays?
Yeah, well, I think that this film and what you've just explained shows how it is important, but you know, the relevance of that testimony depends on the case and what the legal issues are in the case. And in many cases, it may not be relevant. And so what are you going to do as a tribunal? Are you going to let it in? There's a real cost factor to doing that. It's going to slow everything down. For what? It's not going to feature in your award. Who's going to pay for that? The investor? The government? Is that fair? So every tribunal has to first search whether or not it is relevant and it's material to what they're going to decide, and then try to make sure that it doesn't jeopardize the whole process in terms of delay and cost. And what I saw when I was at the PCA, we saw that some tribunals would let amicus in, but the amicus had to bear the cost if there was going to be a cost. So that was one way I saw it being dealt with. Then just in terms of, well, what happens in reality, you know, there's a lot of work around making things more transparent, putting in place instruments, the Mauritius Convention, the RC rules, adapting things so that transparency can occur. But in reality, you see that both states and investors don't want it to be open. They want it privacy. They want it confidential for many different reasons, or they have different degrees of openness that they're willing to consent to. So it might be that they'll list it on the website of the PCA, or they'll allow some information on the ICSID website, but only once the whole case is done will the award be released or not. So I think that over the years, my impression is that while there's a lot of effort to make things more transparent, in reality, a lot of parties on both sides still resist.
We have another question.
My question was specifically regarding a point that Sarah mentioned about the source of counterclaims that a state might bring in. So I was just wondering that there is an increase in ESG claims and how you can bring an ESG claim against a company regarding the greenwashing or something like that. So is it possible that a counterclaim from a state in such situations could be couched in the language of an ESG counterclaim? That it's not a human rights abuse situation, but it's a very commercial and a corporate ESG claim that they bring, that you have promised on your website or in general to your shareholders that this is our environmental stand and your actions don't follow. So could that be a source for a counterclaim to the state?
Yeah, I think yes, but it depends. And what I mean by that is that you have to, the counterclaim needs to be connected to the claim. It needs to be connected to the subject matter of the dispute. So it can't just be a disconnected standalone claim. There has to be that connection. And you do have to source the obligation in law. So it may not be that if it's on your website that's sufficient, right? It has to be within the law or within the contractual matrix that governs your investment.
Thank you. Any other questions from the floor or on Zoom or Slido? Well, there's a question at the back.
There's a lot of talk about transparency. Do you think that a mandatory stakeholder consultation provision, either in the VIP or in the, let's say, like a specific contract between the investor and the state, would somewhat resolve this issue in a way that before making the investment, or the state can have a mandatory stakeholder consultation about how the investment is going to impact that region? What are your views on that?
Yeah, I think that can solve it, but it's a question for the state whether or not they want to better their own decision-making powers by having a mandatory consultation process, and what that means for them. Are they bound by it? Can they resist? You know, there's an amazing investment opportunity that to put in infrastructure roads through their country, but it's going to be resisted by small communities. You know, what is the balancing act for the state? What is their policy? So I think that's a question for governments.
I have a question from Kevin.
To what extent do you think that a restructuring type process is better for these sorts of disputes as compared to arbitration? And I say that with a particular sense that in restructuring litigation, it's often multi-party, different parties' views get taken into account. And the answer is not necessarily legal, because it's a very much a widespread negotiation amongst all the parties. It seems to me that it might, on the one hand, deal with preserving the benefits of the investment, capital flows in, and on the other hand, you know, arrive at a result that might better take into account the different interests around the table. It is, of course, a very radical suggestion, but just thought.
No, I think it's a good suggestion, but I think that, you know, what you often see with investor-state arbitration is that you're at the end of the road, and all the negotiation and all of that has not worked, and the investor is leaving the country, and it's over. But I think, you know, restructuring is obviously much more constructive, and you see it in many different contexts and financing arrangements that things have gone terribly wrong, but there's a way to perhaps salvage things. But I think, you know, in my understanding, once you get to an arbitration, you're usually at the last port of call, unless it's being used as some kind of leverage to try and affect the government to settle in another way or to start negotiating.
Any other questions? Just a final call for questions from the floor. No? Okay, well then I will now draw this panel discussion to a close, and I would like to invite Lilith Nagapetyan, who is an associate at Norton Rose Fulbright in London, and also Trang Tran, who is a manager at Secretariat and the events director of SGVYAP, to deliver the closing remarks.
was a heavy discussion today. Well, we started today with a screening of a very insightful movie of the Tribunal, which shed light on the human impact of ISDS, which often goes unseen. Then we had our discussion with the panel on the interplay between human rights and investment arbitration, including the current framework and in what ways we can increase accountability of human rights issues in the investment process, whether it's by arbitrator appointments, national legislation, amicus curiae, and what role the transparency plays in it all. So we would like to thank very much our esteemed panel for taking their time, Sarah, Hannah, and Luca. And I'm sure all of you will leave today with a bit more insightful reflections on this topic. And also we'd like to thank our skillful moderator, Sunita, for organizing this brilliant event.
Additionally, we would like to thank our event sponsor, King & Spalding, our venue and technology sponsor, 20 Essex, and the Overflow Room, the Flamingo Room sponsor, Maxwell Chamber. We really appreciate your generosity. SG-VYAP are also grateful for our collaborating VYAP sister chapters, namely the VYAP chapters of Colombia, Paris, China, Madrid, Portugal, Paraguay, Australia, and Dubai for their warm and valuable partnership. Further, we are sincerely appreciative of the Ministry of Law support and kindness in respect of this collaboration event. Last but not least, we would also like to express our gratitude to all of you, both in person and online, and especially those in the Flamingo Room, for your participation in this event. Your presence and engagement have made this truly special to us.
I would like now to invite everyone for a glass of cocktail and where we can continue to discuss this very fascinating.
We hope you enjoy the rest of the evening.